5 seconds. Start. As common questions of law and facts arise in these groups of appeals and as such are arising out of the impugned common judgment and order passed by the Customs Excise and Service Tax Appellate Tribunal Principal Bench New Delhi hereinafter referred to as CEST80 Sestat, all these appeals are decided and disposed of together by this common judgment and order that the respective appellants herein are the Krishi Upaj Mandi Samiti Agricultural Produce Market Committees located in different parts of state of Rajasthan. The respective appellants are established under the provisions of the Rajasthan Agricultural Produce Markets Act 1961, hereinafter referred to as Act 1961, that the state government constituted various market committees including the appellants herein in the notified market areas to carry out the functions as envisaged in the Act 1961 and the rules made thereunder, that the respective appellants regulate sale of agricultural produce in the notified markets. They charge market fee for issuing license to traders, agents, factory, storage company or other buyers of other agricultural produce. The appellants also rent out the land and shops to traders and collect allotment fee lease amount for such land shop, that the revenue was of the view that the appellants are liable to pay the service tax on the services rendered by them by renting, leasing the land shops. Show cause notice was issued by the concerned jurisdictional authorities, that after adjudication it was held that the appellants were not liable to pay the service tax on market fee or mandi shulk collected by them. However, the appellants were held liable for service tax under the category of renting of immovable property in respect of renting of lands shops for a consideration. Accordingly, the service tax demands were confirmed. Penalties under Section 76, 77, and 78 of the Finance Act 1994 were also imposed on them. The appellants preferred appeals before the Sestat. By impugned common judgment and order, the Sestat noted that with the introduction of negative list regime of taxation with effect from 1 July 2012, the services in question were excluded from the tax liability and therefore the appellants being an agricultural produce market committee was were excluded from tax liability on and after 1st July 2012. The Sestat also took note of the circular issued by the board. Accordingly, the Sestat held that the appellant's respective market committees are not liable to service tax on renting of immovable property used for storage of agricultural produce in the market area. The Sestat observed that the respective market committees are not liable to service tax on renting shops, sheds, platforms, land in the notified market area for traders for temporary storage of agricultural produce traded in the market. The Sestat also observed that in respect of shops, premises, buildings, etc., rented, leased out for any other commercial purpose other than with respect to the agricultural produce like bank, general shop, etc., the same shall not be covered by the negative list and the market committees shall be liable to service tax. Accordingly, the Sestat held that the appellants market committees are not liable to service tax for the period after 1st July 2012. The Sestat also set aside the penalties imposed on the appellants. The Sestat ultimately disposed of the appeals in the following terms: feeling aggrieved and dissatisfied with the impugned common judgment and order passed by the learned Sestat, holding that the appellant's respective market committees are liable to pay service tax under the category of renting of immovable property service for the period up to 30th July 2012, the respective market committees located in the state of Rajasthan have preferred the present appeals. Sri Prakul Khurana and Miss Divyasha Mathur, learned counsel appearing on behalf of the respective appellants, respective market committees have vehemently submitted that as the activity of allotment of shops, premises, spaces to traders and brokers by the respective market committees for the purpose of storage and or marketing of agricultural produce is in the nature of a statutory activity as mandated under Section 9 of the Act 1961, and therefore the market committees are exempted from payment of service tax on such services as per Circular number 89 7 2006 dated 18th December 2006. Learned counsel appearing on behalf of the appellants have submitted that under Section 9 to Romans 17 of the Act 1961, it is the duty cast upon the respective market committees for allotment, disposal of land or any movable or immovable property for the purpose of effectively carrying out its duties. It is submitted that as per Section 9 to 13, the market committees are authorized to levy recovery and receive rates, charges, fees, and other sums of money to which the market committee is entitled. Therefore, it is the case on behalf of the respective market committees that the activities of the said market committees of allotment, leasing, renting the shop, land, platform is in the nature of a statutory activity, and therefore as per circular number 89 7 2006 dated 18 December 2006, the respective market committees are exempted from payment of service tax on such activities which are in the nature of statutory activity. It is further submitted by Shri Khurana Learned Counsel appearing on behalf of the appellants, respective market committees, that even the fees collected, recovered by the respective market committees on renting, leasing the land shop will be deposited in the market committee fund, and the same shall be ultimately used for the betterment of the market area. It is submitted, therefore, that when the respective market committees are the public authorities constituted under the Statute Act 1961, and when they perform the statutory duty, statutory function of the allotment, renting, leasing of land, shop, the respective market committees are entitled to the exemption provided under the 2006 circular. All these appeals are vehemently opposed by Miss Nisha, learned counsel appearing on behalf of the revenue. It is submitted that all the authorities below have rightly held that the activities of allotment, renting, leasing of the shop, shed, platform, land cannot be said to be a mandatory statutory activity, and therefore the market committees are not exempted from service tax as per 2006 circular as claimed by the respective market committees. It is submitted by learned counsel appearing on behalf of the revenue that Section 9 of the Act 1961 is an enabling provision, and there is no mandatory duty cast upon the market committees for allotment, renting, leasing of the shop, land, platform. It is submitted that even under Section 9 2, the words used are market committee may. It is submitted, therefore, that it cannot be said that it is a mandatory statutory duty cast upon the market committee to allot, lease, rent the shop land. It is urged that the activities of renting, leasing by the market committees to the traders cannot be said to be a statutory activity, and therefore the market committees are not entitled to claim any exemption under the 2006 circular. Learned counsel appearing on behalf of the revenue has submitted that the appellants are claiming an exemption under the 2006 circular, that as held in a catena of decisions of this court, that an exemption notification has to be read as a whole. Stop.